Good evening to the participants of the Andhra Pradesh and state of Telangana JCJ 2023. Karibu sana in Kiswahili. Welcome to my class, virtual class. Please read what I posted on the screen. Anyone can unmute and read what I posted on the screen.
Yeah, Hindu Marriage Act 1955 with virtual class 124-3-2023. This is what we can see in the screen.
Yes, thank you very much. Now, without wasting the time, let me go to shoot. Yes, first question. The answer to this question can be found in the Constitution Bench decision in the Navjot Singh, Johar and others versus Union of India, which declared dash of the Indian Penal Code 1860 a colonial era prohibition and had criminalized the homosexual relations as unconstitutional to the extent that it prohibited voluntary sexual intercourse between the two consenting adults. Now, there are two dashes are there. One is how many judges are there, and another is what section is says about Indian Penal Code of 1860. Options: A, there are 3 judges and section 375. B, 4 judges, section 376, and 5 judges, section 377, and D, 6 judges and section 378.
Option C, 5 judges and section 377.
Right, absolutely right, Lavanya. It's the 5 judges and section 377. Here I have to keep the dashes here. Yes. Now it is clear. So now let us go to the second question. The majority option within bracket Deepak Mishra CJ for himself and AM Karnivalkar J and the conquering opinion of the D.Y. Chandrachud did rely on the dash and Shakti Wahini case on the question of the freedom of choosing a life partners of one's own choice and recognize the sexual autonomy of an individual. What is the dash? A. Shafina Juma. B. Shafin Jishan. C. Shafin Jahan. D. Shafin Janu.
Option A, sir.
WRONG. Try for the second option. No negative marks.
Option D.
WRONG. Now the right answer is C. Shafin Jahan. Jahan. C for cat. Third question. One of the easiest cases, not easiest, earliest cases which dealt with this issue was the dash delivered in the 2006 concerning an intercaste. I did not say intracaste. Intercaste marriage. The Supreme Court held that since the petitioner was a major, she will entitled to marry whoever she wanted to do. That no law bars an intercaste marriage. What is that case law? A. Sarla Mudugal versus Union of India. B. Lata Singh versus State of UP. C. Nandi alias Jainab versus Kron. D. Andal Vidyanathan versus Abdul Allam Vaida.
Option B, sir. Lata Singh versus State of UP.
You are right. It's the Lata Singh versus State of UP. There is another case law also there. We will see it on the same grounds. Okay, fourth question. Muslim individuals marries a Hindu individuals. Which option is correct option among the 4 options? A. Yes, he may marry under the Christian Marriage Act. B. Yes, he can marry under the Parsi Marriage Act. C. Yes, he can marry under the Special Marriage Act 1954. D. Yes, he can marry under the Hindu Marriage Act of 1955.
Option C.
Option C is the right answer because Special Marriage Act will not see the caste, creed, anything, religion, faith, color. Fifth question. Anyone can unmute and read the fifth question?
Hindu Marriage Act 1955 applies to any person who is Hindu by option A faith, option B belief, option C creed, option D religion. Option D religion is the right answer.
Religion is the right answer, not the faith, belief, and creed. So, sixth question. These conditions are as follows. Which option is the correct option? Number 1, neither of the parties spouse living at the time of the marriage. 2, both the parties must be of sound mind and capable of giving the valid assent to the marriage. 3, the parties are not engaged within the degree of the prohibited relationship. 4, the parties are not subpoena of each other for the valid marriage under the Hindu Marriage Act of 1955. A
Option B.
B 1 plus 3 plus 4, C 2 plus 3 plus 4, D 1 plus 2 plus 3 plus 4.
Option D 1 plus 2 plus 3 plus 4.
WRONG. In one of the 1, 2, 3, 4.
1 plus 3 plus 4, option B, sir.
Option B is 1 plus 3 plus 4. The reason is
C, sir.
valid consent,
Valid
not
consent.
assent. Valid consent to the marriage, but I changed it. So that is the way also a question can be asked. Seventh question. The plaintiff was the president of the NGO named Kalyani, which aims to help the women in distress. Meena Mathur, who was married to Jitendra Mathur in 1978, found that her husband Jitendra Mathur married another woman named Sunita Narula alias Fatima. Petitioner has learned that both the Jitendra Mathur and the Fatima were converted to Islam before the solemnizing the marriage. Fatima contended that the purpose of the converting themselves to Islam and adopting the Muslim religion is to marry each other and circumvent the provisions of Section 494 of the Indian Penal Code 1860. The fact of the case law is, yes, anyone? The fact of this case law. Sir, show the option. If I show the option, definitely you will give the answer. Yes? Options. A. Abdul Vaidyanathan versus B. Abdullah Alam Vaida. B. Budansa versus Fatima. C. Sarla Mangal Mudgal versus Union of India. D. Nandi alias Zainab versus Crown.
Option B.
Option C, Sarla Mudgal.
Because you saw Fatima there and I put Fatima here. So that you could commit the mistake. It is the case law of the Sarla Mudgal versus Union of India. Very famous case law. By converting merely to the Islam to get married, no, when the first wife is alive, it's amounts to bigamy. Yes, take the divorce from the first wife and you can marry to anyone. Are you following me?
Yes,
Say
yes.
Say yes.
Yes, sir.
Good. Eighth question. Section 377 criminalizes the consensual sexual acts of the adult. That is the person above the age of 18 years who are competent to consent in private is the violative of the dash of the Constitution. Which option is the wrong option? A. Article 13. I think wrong option I said. No. Articles are there. Where is the question option comes? Yes. Okay, now. A. Article 13. B. Article 15. C. Article 19. D. Article 21. Yes, wrong option.
21, I think.
Yes?
I think Article 21,
Option A, sir. Article 13.
Article 13,
which is wrong,
but
I think.
actually
Option.
should be Article 14. Article 14, Article 15, Article 19, Article 21. With that, 377 is unconstitutional. So I removed the 14, I put the 13. That is the reason I asked which option is wrong option. Now, ninth question. 5 judges involved in the decision of the Navtej Singh Johar versus and others versus Union of India and others. And who are the 5 judges? And 1, 2, 3, 4 option. Chief Justice Deepak Mishra. 2. Justice A.M. Khanwilkar. B. Justice Rohinton Fali Norman. 4. Justice Y. Chandrachud and Justice Kuldeep Singh. A. 1 plus 2 plus 3. B. 1 plus 2 plus 4. C. C plus 2 plus 4. D. 1 plus 2 plus 3 plus 4.
Option
Option B, sir. 1, 2, 4.
See, intentionally
I
what
think
I
all,
did
sir.
now,
Option D, I think 1, 2, 3, 4. And all the justices are there.
of course, Deepak Mishra is the Chief Justice in that case law. A.M. Khanwilkar also there, no doubt at all. Justice Rohinton Fali Nariman also there, and there is a dissenting or a judgment is given by the D.Y. Chandrachud and Justice Kuldeep Singh. I don't think the justice also given. No, he has given the consent only. Justice Kuldeep Singh, I changed it. Actually, there is no Justice Kuldeep Singh. And there actually is Indu Malhotra. These are the 5 judges who gave the judgment of the Navtej Singh Johar and other versus Union of India. But you have to choose from only the options, hence you should not make any assumption and presumptions. The right answer is 1 plus 2 plus 3. Is it clear? Say yes.
Yes, yes.
So now let us go to the next 10th question. On the 27th April 2016, Dash from the LGBT community filed a new writ petition in the Supreme Court challenging the constitutional validity of the 377 of the IPC. How many people are there from the LGBT? A. 5 people. B. 5 people. What is it? No, I repeated. 6 people. D. 7 people. How many people are there from the LGBT? Supplementary question. Was it LGBT? First you answer the first question. How many from the LGBT community filed the case? That is the first supplementary question.
5.
5 is the right answer. What is LGBT?
Lesbians, gay, bisexual, transgender.
Yes. So these are called the LGBT. In other ways, we can say Koja also in Telugu. Okay, 11th question. Initially, the case was placed before the 2 judges bench, Justice S.A. Bobde and A.K. Bhushan, wherein order was passed to post the matter before the Chief Justice of India for appropriate order. Eventually, on the 8th January 2018, Chief Justice bench passed an order stating that the case will be heard by a dash bench. 2 judges bench, division bench, full bench, constitution bench, ABCD.
B. Division bench.
Division bench.
WRONG. It is the constitution bench. The matter is referred.
Constitution.
Yes, that is the right answer. 12th question. In dash, Honorable Judge has said that the Family Court Act expects the duty holders like the court counselors welfare experts, and any other collaborators to make efforts for the reconciliation. In which case law it is A. Santini versus Vijay Venkatesh. B. Vaddiraju Sweta versus Vaddiraju Dilip. C. Mangaturthi Sarala versus not WG district, West Godavari district versus Magruti Sachinarayana. D. Katuri Sai Sandhya Kottagudem versus Katari Balaraju Guntur district.
Option A, Santini versus Vijaya Venkatesh.
You are right. Santini versus Vijaya Venkatesh. Here, I don't know whether you know it or not. In one place I belong because I born over there. Which is that place?
Vijayawada, sir.
Yes? I say place. In the case law, there are two places the place names are given. One is West Godavari district, another is Kottagudem.
Kottagudem.
I belong to Kottagudem. I brought up born over there in the Kottagudem, which is earlier called near to the Bhadrachalam road, Boguta, near to the Boguta. It comes under Khammam districts at the time, now also. Okay, now let us come to the 13th question. In Shantini versus Vijay Venkatesh, Honorable Dash has said that Family Courts Act expects the duty holders like the court counselors, welfare experts, at any and other collaborators to make the efforts of reconciliation. Now you tell me, A. Justice Kuldeep Bhushan, B. Adarsh Kumar Goyal, C. Uday Umesh Lalit, D. Mr. Justice Kurian Joseph. Who is the judge in Shantini versus Vijay Venkatesh case law? Even the judges' names also can be asked in the remarkable and landmark cases. Like I told you, Navajit Sidhu case law, Shaini Abraham case law.
Adarsh Kumar Goyal, sir.
Who is the judge here? A, B, C, D. In the 13th question.
B answer. B.
WRONG.
Option A, sir.
WRONG.
Kuldeep Bhushan. Option D.
Option D, Justice Kurian Joseph. One of the case law, I already told this Kurian Joseph was there, and already wrong Nariman also there. I told you once. Okay, now 14th question. On 20th February 2023, the Supreme Court rejected a petition filed by Dash aimed to increase the age of marriage for a woman from 18 to 21. Who is the advocate? A. Advocate Arshad Upadhyay. B. Advocate Hassan Upadhyay. C. Advocate Kashyap Upadhyay. C. Advocate Ashwini Upadhyay.
Option D, Ashwini Upadhyay.
Option D is the right answer. It is Ashwini Upadhyay who filed a case to increase the women's from 18 to 21, but it is struck down. But anyway, another question we do have, like, that is the bill section, Bill 21, 2021 and 2022. They have planned to increase the same age. Okay, 15th question. A marriage between a Hindu man who converted as a Christian and a Christian lady in a Hindu form is not a valid marriage. According to Section 5 of the Act, marriage can be solemnized by two Hindus dash. In which case law it is decided? A. CMP Ashraf versus Rajashree Pawar. B. Prasanna Periyara versus Rakeri Periyara. C. M. Vijay Kumari versus Devabalam. And D. Srimati Prasanni Devi versus General Manager North Railways.
C answer. Vijay Kumar was there.
C is the answer. Vijay Kumari versus K. Devabalan. 16th question. Unmute and read. Anyone can unmute and read. 16th question. I said read.
To brand the wife as unfit of the marriage and the procreation of the children on the account of the mental disorders, it needed to establish that the element suffered by her is of such kind or such an extent that is impossible for her to lead a normal life, observed in the case of
A. Prakash Kumar Bachlas versus Srimati Chanchul and Jaya. B. R. Lakshmi Narayana versus Shanti. Srimati Ram Sakhi Devi versus Chhatra Devi and others. D. Nandakishore Agrawal versus Srimati Meena Agrawal and others.
answer C, sir.
WRONG. Second option.
Option B.
Option B is the right answer. R. Lakshmi Narayan versus Shanti is the right answer. Now the 17th question. How many sections are repealed under the Hindu Marriage Act of 1955? A. 0. B. 1. C. 2. D. 3.
Zero, sir. Option A.
Option
A.
0. WRONG.
Yes, sir.
2, I think, sir.
WRONG.
B1.
B1. And I can challenge if you could see such a question which I framed just now. 18th question. Which section of Hindu Marriage Act of 1955 is repealed? One is okay, but which section?
Option B. 28.
WRONG.
Section 27, sir. A.
WRONG.
Sir, section 29.
WRONG.
30D.
30. It is an open challenge if anybody
Yeah, I
makes
told
such a
30
question.
on.
Okay, 19th, match the following. 21, application of Act of 1908. I say mismatch the following. A. 21, application of Act 5 of the 1908. 2. 21, capital A, documentary evidence. 3. 21, capital B, special provision relating to trial and disposal of the petition under the Act. 4. 21C, power to transfer petition in certain cases. Options. A. 1 plus 2, B. 2 plus 3, C. 2 plus 4, D. 3 plus 4. I say mismatch.
B. 2 plus 3.
WRONG. Second option.
C. 2 plus 4.
It is a 2 plus 4 is the right answer. See, you can see here. Feedback. 1. 21, application of the Act of 1908. 2. 21, capital A, power to transfer the petition in certain cases. And 3. 21B, special provision relating to the trial and disposal of the petitions under the Act. 21C, documentary evidence. Which statement is wrong? A, B, C, D I have given. A. The bridegroom has to complete the 21 years of age and the bride has to complete the 18 years of age at the time of their wedding. B. The couple could not be prohibited relationship unless the traditional permits them to get married. C. The couple should not be subindos, within parentheses cousins, unless their custom permits them to get married. D. One should not marry when his spouse is still living without obtaining a divorce. Which option is wrong option?
C.
The couple should not be subindas. Yes, true. Unless their custom permits them to get married. It's a true statement. Intentionally, I twisted one word among the ABCD.
Option
Option
D is the right answer, sir.
which is the wrong statement? Again, say. Say, pass on. I will give the answer. Don't waste my time.
D.
DOG dog. D for Delhi.
Yes, sir.
Answer A, I think, sir.
WRONG. See, if you happen to see option B, the couple should not be prohibited relationship unless their custom permits, not tradition permits. Their custom permits them to get married. Is it clear? Say yes.
Yes, sir.
Good. It is an open challenge if anyone can give the answer. How many times wedding term is used under the Hindu Marriage Act 1955? It is an open challenge to anyone. If you give the right answer, I will give the gift to you.
A 0.
3 times D answer.
0 is the answer. Yes. Gift will follow with that wedding asked. Then how many times marriage word would be used in the Hindu Marriage Act?
1.
Here they given 112, B 113, B, C 114, D 115. Now you are entitled for the gift. Now you will be entitled for the gift.
114.
It is 114 is the right answer. Yes, you are entitled for the gift. I can send you the gift through the Western Union money transfer. On your name. You write your full name, I will give the gift to you through the Western Union money transfer. It is 114 times when the marriage is used and 0 times the wedding is used. There is no word wedding in the Hindu Marriage Act. And how many times marriage, the word marriage is, yeah. Already it is given over there, so I need not to make it out. So Lavanya is entitled for my gift. I will send through the Western Union transfer, money transfer, and you can send your total detail to me. Then you will entitled for the what is the. Yes, now next question. 23rd question. In India, when a Hindu and a non-Hindu marry under the Hindu Marriage Act, for the Hindu marriage to be dashed, both partners must be Hindu amongst their other conditions that also need to be fulfilled, and the non-Hindu partners must convert to Hinduism. A. Invalid. B. Voidable. C. Valid. D. Void.
Valid, I think.
It is the valid is the answer. 24th question. Dash of a marriage age shall have the right to marry and to find a family according to the national laws governing the exercise of this right. A. Men and men. B. Man and woman. C. Men and women. C. Men and women.
B. Man and woman.
Which one? Option A, B, C, D.
C. Men and women. C.
WRONG. The right answer is D. D for Delhi. Men and women. Both are plural form. 25th question. Which statement is the wrong statement? A marriage between a Christian and a Hindu woman is not legally valid if either of them does not convert. B. If you both wanted to solemnize the marriage as per the Hindu custom. C. You should have converted to Hinduism, or the woman should have converted to Christianity if she wanted to do as per the Christian customs. D. If the prohibition of the child marriage within parentheses Amendment Bill 2022 is passed this with a majority both the houses of the parliament, it will be a 21 of year for both the boys and girls. Which one is the wrong option?
C, sir.
WRONG.
Option A.
WRONG.
D.
See, I told you also, I can change in the year also. Here 2020, not 2021. I changed it. It is not 20. Actually, it is 2021. So, the wrong option is
D.
D. 26. The Supreme Court on Monday observed the only Hindus can marry under the Hindu Marriage Act, and any marriage between the interfaith completes under the same void was observed in the case of. I think this is a double lie repeated, but the case lie is different. A. Dayashankar versus High Court of the Allahabad and others. B. Muzaffar Hussain versus State of Uttar Pradesh and others. C. Ajay Matthew versus State of Telangana and others. D. Rajendra Prasad Bharti versus State of UP through Additional Chief.
D, I think.
Shoot. Among the ABCD, which is the right answer? Still
Option A.
WRONG. Next. Second option.
B.
Read full.
B. Muzaffar Hussain versus State of UP and another.
WRONG. Next.
D. Rajendra Prasad Bharati versus
WRONG.
State of UP.
Ajay Matthew was the State of Telangana.
Ajay P. Matthew versus State of Telangana and others. It is the right answer. Lavanya, Charaneka Murigu Baranaka Masala ante తెలుసా అండి మీకు?
No, sir.
చారానే అంటే 25 NP. చారానే ముర్రి అంటే hen. Charane Murgi cost is only Charane means 25 NP, but the masala is 75 NP.
So, sir,
Barana masala. For sending your Zawadi, Western Union, I have to pay the more amount. Hence, I will send your Zawadi means gift. In Kiswahili, Zawadi means gift. I will give the gift to your. Do you have the Google Pay or Phone Pay?
So we have everything.
Yes, sir.
We should also get that.
Lavanya is entitled. You did not give the answer.
So I
And
gave
frame
the
the
answer.
two questions. It is an open challenge. If you could see that questions in any one of the book,
Which ones are which questions?
you did not know. How many times wedding is used
The
in the
answers
Hindu
which are
marriage
already
act?
mentioned there.
Number 1. 21. How many times wedding term is used in the Hindu marriage act? Answer is?
Zero.
0. Now, how many times the word marriage or marriages were used in the HM Act, in the Marriage Act?
114, I think.
114.
114.
114 times it is used over there. I don't know how
That's
Lavanya
the
got this
1144.
point. How, Lavanya, how did you shoot it actually? You guessed it?
For the first question, nowhere wedding has been used in Hindu Marriage Act, sir. That
Okay.
question I know, sir.
Okay.
Whereas the first section, question number 22, just I guessed 114.
See, I trained you in such a way when you don't know the answer also, you can shoot the right answer. What is the technique?
Yes.
Because you frame your mind in such a way in different angles and you apply the mechanism of mind and you can shoot the answer without knowing the answer.
Yes.
See, I trained you in such a way. That's why don't take any bare act. Don't take any book while you are going to the examination. And don't read also at least 12 hours. You give the mind rest. I am sure that your mind will brainstorm in such a way you would get the right answer without knowing the answer also. So that is the thing. So Lavanya, I know your number because I saw from there. So I can send you the either Google Pay or your phone pay. So now these are the 26 questions I have framed it today. And the next class, what you are going to deal? Anyone? I already kept it here, yeah. And today is the 24th. The next class, 25th March, Telangana Prohibition Act 1995. I will deal both Telangana as well as Andhra because same acts are there, nothing changed except some of the cases
Telangana
which have come up.
Prohibition Act,
I
not
don't know
this.
because earlier it is the Andhra Pradesh Prohibition Act. Earlier, but now they changed it to Telangana Prohibition Act and Andhra Pradesh Prohibition Act 1995. So now the question comes over there. I will ask one. See, I am not a politician. No, I am not any. I will ask the question. Can the state, big state is good or small state is good? My question is.
Small.
If the small state doesn't have the natural resources, always keep in the mind, natural resources
Then go it.
is more important, number one, and all the transport, most of the transport done, how? Transport, how it can be done, most of the transport.
Roadways.
Run.
Railways.
No roadways, no railway line, no airplanes. Then
Waterways.
what do you call harbors? The world transport, most of the freights having the very weight will be transport through the ship, sailment vessels. And a country which is having harbor, a country which is having natural resources, and that would be the richest country. A landlocked country is, even though having most of the resources, but still it is not compete with the other country. What is landlocked country?
No water served it.
There would not be adjacent, there is no sea. And everywhere only land. I don't know whether you remember it or not. Ethiopia. Is it a landlocked country? Answer is yes. But Eritrea, which is the part of the Ethiopia earlier, it is the harbors are there. Not one, two harbors are there.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full